Welcome again to this lecture series. So today we're going to be talking about something very, very important, something that bothers so many people. The question here is, can you be arrested for defaulting in a loan repayment? Truth is, most of the companies you see around corporate institutions, they borrow money to fund their business. But of course, because the business is a going concern and they're making profits, they are able to repay their monies, the monies they borrowed. And this borrowing is not limited to companies and businesses alone. So, individuals also borrow money, families borrow money just to meet up some of their needs. And there may be one or two reasons why you're unable to pay. As at the time of borrowing, of course, everybody would have the plan to pay. Who wouldn't? I mean, except for those who are recalcitrant borrowers or those who just want to be bad. They borrow money without any intention to pay. But a reasonable man will borrow money because he intends to use the money for something urgent or to finance his business with the intention to repay. And sometimes collateral is deposited before the money is advanced, and other times there's no collateral. Now the question is, you may default. If you default, can the police arrest you? Can your creditor call the police, petition you at the police station with the EFCC or any of those law enforcement agencies to get you arrested? Now, the straight answer to this is that a loan agreement, loan transaction is purely civil. So therefore, it is illegal and unconstitutional to involve the police in recovering loans and debts. The police and other law enforcement agents are involved in criminal matters that have to do with criminality. So, for example, obtaining money by false pretense. So, when you steal from someone, you take money from someone by making false representation, that is criminal. In that case, they can involve the police. Or where you outrightly steal from someone, in that case, they can involve the police. But when you borrow money from someone with the agreement that you will repay the money with interest, and the date to repay comes and you're unable to repay, the creditor is not allowed by law to involve the police. At best, what the creditor can do is to make an official demand. Then, if you're still recalcitrant, you're not paying, he takes you to court. And then the court will compel you to pay. And of course, you can then attach your accounts and get the monies paid directly from your bank to him. All right, but that has to go through the court process. Now, why is it illegal to involve the police in debt recoveries? If you are a creditor listening to this lecture, you must avoid the urge to resort to self-help. It's very tempting. When you go to a debtor and the debtor tells you, do your worst, I'm not paying, there's no money. It's look at the regime, it's Buhari regime. There's no money anywhere. The ground is dry. Even you, are you not feeling it? Is the economy not touching you? But you're like, bro, I borrowed you this money, and it's not because I have too much. I borrowed it to you because it's business. And you're telling me, so you're tempted to involve the police and just deal with this person. But do not do that, because if you do that, the debtor may now have an upper hand over you, because he can now then take you to court for doing something illegal, for harassment, for threats, for assault, and all of that. And if the police arrest him for false imprisonment, and you can file a fundamental right action against you, he can even claim damages against you. So you're not the one to pay him instead of him paying you. You know what that means. And of course, if he takes you to court, you may now have to now brief a lawyer and paid lawyer and all of that. So do not involve the police. Write an official demand letter, and then take him to court. All right, instead of resorting to self help. But of course, there are instances in cases of debt recovery where you can involve the police. One, where your debtor issues a dud check. All right, and let me say this as if I'm advising the creditor. In the course of trying to get your money back from your debtor, you can ask him to issue you a check. Of course, the check may bounce, on the set date. So if the check bounces, immediately that triggers something criminal because it's a criminal offense. You can use that to invite the police into the case. Someone issued a dot check, and I presented the check, it bounced, and that makes the person a criminal. So the police comes in and uses that to arrest the person, and in that case, you have not done anything illegal. So in cases of issuance of dot checks, you can involve the police. And another thing you can really do if you don't want to involve the police, of course, it is illegal to involve the police, is that in the course of trying to recover your debt, this is to make your civil case very easy. Make sure your demands are in writing, and make sure you are able to extract commitments from the debtor, agreeing that he's actually owing and that you just need more time to pay. In that case, you go to court and you get a summary judgment. I hope this video has been helpful. This audio and this lecture has been helpful to you. If yes, please click on the subscribe button, like, share, and comment. Thank you.